Okay, let's dive into this. Have you ever wondered exactly how a legal case actually climbs the ranks of the justice system? Why certain everyday crimes are handled locally while others turn into massive national news? Well, today in this explainer, we're going to visually map out the legal system's ascending hierarchy. We'll start all the way at the ground floor, where everyday disputes begin, and we'll climb rung by rung, all the way up to the heavyweights of the appellate courts. And hey, make sure you stick around because by the end, we'll even look at how you might bypass this entire ladder completely. Here is our roadmap for today. First, district courts, the foundation. Second, regional courts, where the stakes get higher. Third, high courts for the major cases. Fourth, the Supreme Court of Appeal. And finally, skipping court entirely with alternative dispute resolutions. Section 1. District courts, the foundation. So we've got 4 distinct steps in this hierarchy: district, regional, high, and the Supreme Court of Appeal. And this structure brilliantly illustrates our mental map, starting right here on step 1. This flow is absolutely crucial to understand because, well, you can't just jump into the highest court simply because you feel like it or because you're particularly angry about your case. You've got to follow the jurisdictional rules. So what exactly makes a district court? Well, a district court. First off, the person in charge, the presiding officer, is a magistrate, not a judge. And importantly, this is a court of first instance only. What does that mean? It means a case absolutely must start here. You cannot bring an appeal from another court down to a district court. It's the starting line. It's where raw facts are established and evidence is presented for the very first time, all regulated by the Magistrates Court Act 32 of 1994. Now, because it's the absolute foundation of the legal system, its punitive power has a strict ceiling: 3 years. A district court magistrate literally cannot sentence anyone to more than 3 years in prison. It's a deliberate design, right? It keeps the scope of these local courts focused on less severe infractions, which allows them to efficiently process a really high volume of everyday cases. To put that 3-year limit into perspective, the district court successfully handles common, everyday issues: theft, assault, civil disputes valued under 200,000 Rand, and they can issue criminal fines maxing out at 120,000 Rand. But there are strict prohibitions. They absolutely cannot touch severe crimes like murder, rape, or treason. No way. They also can't deal with the validity of wills, determining the legal status of a person, like, say, declaring someone mentally ill, or making constitutional rulings about the president. So that begs the question, if a horrific crime like murder can't be tried here, where exactly does it go? Section 2. Regional courts, higher stakes. Let's move up a rung and see how this builds. At this level, the ceiling is raised drastically. Instead of a mere 3-year maximum, regional courts have the formidable authority to hand down prison sentences up to 15 years. That is a massive jump in severity, responsibility, and obviously the impact it has on a defendant's life. This increased sentence limit exists specifically because regional courts handle those severe, life-altering crimes we just talked about, like murder and rape. On the financial side, they deal with civil cases ranging from 200,000 up to 400,000 Rand. They manage divorces, and they can issue massive fines up to 600,000 Rand. But, and this is a big but, even with this heavily increased power, they still have boundaries. They cannot try crimes against the state, like treason, and they still can't handle wills or determine the status of a person. For those highly specific, really complex issues, we've got to keep climbing. Section 3. High courts, major cases. This shift in power here is monumental. First off, you're not facing a magistrate anymore. The presiding officer is a judge, and the court itself is led by a judge president and a deputy judge president. But the absolute most critical difference, the high court functions as both a court of first instance and a court of appeal or review. That means under the Superior Courts Act of 2013, a high court judge can hear a brand new, highly complex case right from scratch, or they can sit and review and actually overturn decisions made by the magistrates in those lower courts we just went over. The high court handles a massive scale of issues. We're talking treason, life sentences exceeding 15 years, huge civil claims over 400,000 Rand, fines over 600,000 Rand, wills, determining a person's status, and divorces. It is incredibly comprehensive. But there's a really fascinating constitutional limitation here. Even the powerful high court has a ceiling. If a high court declares a piece of legislation or, say, presidential conduct constitutionally invalid, that ruling actually has no final effect unless it's ratified by the absolute highest court of the land, the Constitutional Court. It's a pretty brilliant check and balance, right? Section 4, Supreme Court of Appeal. Now, what's really interesting here is that this is a court of appeal only. Unlike the High Court, the Supreme Court of Appeal never hears a trial for the first time. There are no witnesses taking the stand here. None. They strictly review the application of the law from previous trials. The presiding officers are highly experienced judges of appeal, headed by a president and a deputy president. And to ensure the absolute highest level of legal scrutiny, they usually require a quorum of 5 judges just to hear a single case. When it comes to criminal and civil appeals, there is zero limitation on their jurisdiction. Their rulings are absolute, and they are binding on all the courts below them. Once the Supreme Court of Appeal makes a decision on a non-constitutional matter, that is it. That's the final word for the magistrates and the high courts. Think about it. We've climbed from a restricted 3-year maximum sentence at the district level all the way up to absolute binding appellate power. Section 5. Skipping court. Alternative disputes. Now, I want you to ask yourself directly, what if you want to avoid the courtroom entirely? Seriously, what if you find yourself in a civil dispute and you just do not want to endure the escalating stakes, the massive financial costs, and the literal years of waiting associated with the court system we just mapped out? Well, fortunately, for civil matters, there are entirely different paths available. So, the crucial point is understanding the differences in how you can actually resolve disputes outside a courtroom. First up, negotiation. Here, the parties decide the outcome entirely themselves. No third-party helper. Just you and them aiming for a win-win scenario. The control is 100% in your hands. Second is mediation. You're still aiming for that win-win and you still make the final decision, but you bring in a neutral third-party mediator to basically help guide the conversation and cool tempers. And finally, arbitration. Here, you're handing over control. A third-party arbitrator makes the decision, and the outcome is typically win-lose. A lot like a judge's court ruling, but it's often way faster and much more private. So considering everything we've mapped out today in this explainer, from the rigid 3-year ceilings of the district courts to the absolute binding authority of the Supreme Court of Appeal, which path gives you the best chance at a win-win without the gavels? The legal ladder is incredibly structured, and obviously it's there when society desperately needs it. But sometimes the smartest, most efficient climb is choosing to step off the ladder altogether. Thanks for joining me, and keep looking for the clearest, most effective ways to solve the complex problems in front of you. See you next time.